about triple the amount of cases that we were able to do the last year with all the new cases. So we've closed out, I think, 2 fiscal years. And so we should be able to continue getting triple the amount that we were prior to these new procedures that are in place.
That's correct. Thank you. Any other questions?
Anything further for Jeff? If not, let's move on to item number 4, the approval of the commission meeting minutes from our last meeting, August 4th, that have been circulated. Do I have any motions in that regard to amend or accept?
Move acceptance.
Okay, we have a motion to approve. Do we have a second?
Second.
All right. If there's no other discussion, all in favor, please say aye.
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 Anyone opposed? The minutes are approved. Then if we could, let's move up to 5, what we talked about earlier, the approval of commission settlement actions and the issuance of final orders. Our first area is guardianship certification, item A.
Good morning, Commissioners. Vina Mohan, prosecuting attorney. In the matter of Francisco Cisneros, the respondent agreed he violated minimum standard 5B concerning staying current with services and providers, and 13F7 concerning maintaining a record of each in-person visit. And he violated this by falsely documenting no changes to his ward's medication or diagnosis on dates that post-dated the ward's death. The respondent did not agree that he violated minimum standard 21A by accepting additional appointments. Per the terms of the agreement you have in your materials, the respondent did not accept liability for this because he felt he took measures to let his supervisor know that he needed help with his caseload. The respondent has agreed to the following: the commission suspend his certification for a consecutive 6-month period effective the date of the final order, and that he must complete 3 hours in ethics in addition to the 12 hours of continuing education required for recertification. We ask that the commission approve the settlement and issue the final order for this case.
Any questions, Ms. Mohan, regarding that? If not, do we have a motion to approve the settlement of cause number 0482?
So moved.
Do we have a second? Any other discussion? All in favor, please say aye.
Aye.
Anyone opposed? The motion does carry. Moving on to our settlements under the court reporter certification, item B 0417, Ms. Mohan.
Thank you, Your Honor. The respondent agrees that she violated Code of Ethics 4B1 and 7E and 8B because she never provided to the complainant 6 transcripts she was hired to produce. The respondent agrees to a reprimand and an administrative penalty of $950 total due within 12 months after the date of the final order. We ask that the commission approve the settlement and issue the final order for this case.
Okay, and cause number 0417, do we have a motion to approve the settlement?
So moved.
Second?
Second.
Any discussion? All in favor, please say aye.
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 Anyone opposed? Motion carries. Cause number 0443, Ms. Mohan.
Thank you, Your Honor. The respondent has agreed to the following violations by providing a transcript 171 days after receipt of payment. The respondent violated Code of Ethics 4B1 by providing a transcript to the complainant untimely after receipt of payment, and by failing to provide the complainant with an explanation of her delay. The respondent violated Code of Ethics 7E and 8B. The respondent has agreed that the commission issue a reprimand and assess an administrative penalty of $950 total due within 12 months after the date of the final order. We ask that the commission approve the settlement and issue the final order for this case.
Okay, do we have a motion to accept the settlement?
So moved.
Second?
Second.
All in favor, please say aye.
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 Anyone opposed? Motion carries 0448. Ms. Mohan.
Thank you, Your Honor. The respondent has agreed that that he violated Code of Ethics 4B1 by providing the complainant a transcript 391 days after the respondent received payment. The respondent violated Code of Ethics 7E and 8B by providing the complainant a late transcript after receiving payment and by failing to immediately notify the complainant of the delay. He has agreed that the commission issue a reprimand and assess an administrative penalty of $950 total due within 12 months after the date of the final order. We ask that the commission approve the settlement and issue the final order for this case.
Do we have a motion to approve the settlement and issue the final order?
So moved.
Second,
Second.
any other discussion? All in favor, please say aye.
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 Anyone opposed? Motion does carry. Our final one is under process server certification 0404. Ms. Mohan.
Thank you, Your Honor. We allege that the respondent violated Code of Ethics 2A by submitting an inaccurate return of service, which stated that he personally served the complainant when he did not. The respondent admitted that while the complainant was inside her home, he placed the documents on her vehicle inside her garage. The respondent does not accept liability for this violation. The parties agreed to settle primarily to avoid a protracted trial and the expense of litigation. We were less concerned about him paying a financial penalty and more interested in him completing CE, which he has agreed to do. And he said something to the effect that education is always a good thing. We ask that the commission approve the settlement and issue the final order for this case.
Okay, in regard to Everett Moore 0404, do we have a motion to approve the proposed settlement?
Could I ask a question, Mr. Chairman?
Yes, sir.
Ms. Mohan, was the return, did he verify or swear that he personally served the defendant? I assume that he did.
Yes, he did that.
Okay. And in fact, the person was in the house and he laid the papers on the car.
That's correct. And he admits to those facts.
I mean, he made a false statement under oath. Is that right?
Yes, he did.
Yeah. I just wanted to comment that sounds like a false return. And in the future, I would hope that we would look at that harder. That's all I've got at this time.
And Mark, can I add that during the settlement talks, we actually discussed what happened, and she evidently was out there and then she went inside, and he was under the assumption that placing it on the car was a drop serve or a personal serve, and we explained that you can't do that. So I think our staff honestly felt that he was mistaken rather than trying to deceive somebody. So I think I have that right, Vina. Is that how you recall it?
Yes.
All right. Thank you.
Glenda, anything else? Okay.
Not for me.
Then, do we have a motion to either approve the settlement and issue the final order, or amend or reject the settlement from anybody?
Motion to approve.
Do we have a second to approve?
Second.
Any other discussion? All in favor, please say aye.
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 Anyone opposed?
Opposed.
All right, one
I'm opposed.
opposed, two opposed. Anybody else? Motion will carry. Showing two opposed. Okay, moving on, then we're up to Roman numeral number 6, the approval of the commission disciplinary actions by default. beginning with the process server certification. Ms. Mohan, you can take them up individually or together, whatever you would like to do.
Okay. Yeah, I guess to prove notice, Your Honor, and each case varies, maybe each individually, but I would like to expedite things by offering into evidence all the exhibits for these cases.
Okay, who's gonna be sworn in?
Melinda Saucedo.
Melinda, you ready? Would you raise your right hand for me, please? You do solemnly swear the evidence and the testimony given the cause will be the truth, so help you God.
Yes,
All right, I will admit the exhibits that were tendered by Ms. Mohan in each of the cases. You may proceed.
Thank you, Your Honor. With respect to Daniel Garcia, Ms. Saucedo, the case concerned the allegations in the notice of violation letter.
yes,
Did you notify the respondent of the committee's determination by first-class mail, certified mail, and email?
yes,
Did you mail a letter dated October 3rd, 2023, notifying him of his rights and requesting a written response?
yes,
Is that exhibit 1 for this case?
yes,
Isn't it true that the letter sent by email and first-class mail were not returned?
yes,
Isn't it true that the letter sent by certified mail was unclaimed?
yes,
Were all the letters you sent to his last known mailing address on file with the commission?
yes,
Did you receive any response from the respondent?
no,
Did you notify him of the meeting and he is not present today?
yes,
Your Honor, I believe we've established that the respondent had notice of the violations assessed against him and his rights. We move for a default order. We ask that the commission move to adopt the findings of fact and conclusions of law outlined in detail in Exhibit 1 and adopt the sanctions stated in Exhibit 1.
All right, do we have a motion to issue the final order by default and adopt the findings of fact?
So moved.
Second,
Second.
any further discussion? All in favor, please say aye.
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 Anyone opposed? Motion carries. Cause number 0418, Ms. Mohan.
Thank you, Your Honor. Ms. Saucedo, did this case concern the allegations in the notice of violation letter?
yes,
Did you notify the respondent of the committee's determination by first-class mail, certified mail, and email?
yes,
Did you mail a letter dated October 3rd, 2023, notifying her of her rights and requesting a written response?
yes,
Is that Exhibit 1 for this case?
yes,
Isn't it true that the letter sent by email and first-class mail were not returned,
yes,
and the certified mail letter was unclaimed?
yes,
And all the letters were sent to her last known mailing address on file with the commission?
yes,
And you did not receive any response, and the respondent is not here today?
correct.
I believe we've established that the respondent had notice of the violations and was notified of her rights. We move for a default order. We ask that the commission move to adopt the findings of fact and conclusions of law outlined in detail in Exhibit 1 and adopt the sanctions in Exhibit 1.
All right, do we have a motion to issue the final order by default and adopt findings of fact, conclusions of law?
I had a
So moved.
question, Mr. Chairman.
Yes, sir.
The suggested sanctions on this, Ms. Mohan, that's $2,500 penalty as part of it. Is
Yes,
that right?
that's correct.
Um,
And as well as a CE.
yes. In this case, this is a false sworn return case, is it not?
Yes, I believe so. She claimed to have served the complainant on a specific date and did not do so. And we assessed a maximum penalty against her of $500.
Right. The findings of fact in this is I believe this is Mr. Renard's letter or Ms. Saucedo's letter of October 3rd. The findings of fact are number 2, you falsely stated in a return of service dated January 21, 22, that you personally served the complainant on January 18 at 3:13. And number 4 is, more importantly, I think, you admitted you may have left the documents with the complainant's spouse and apologized in your answer in response to the complaint. Is that correct?
Yes.
And so he swore personal service, and the finding was that he served the complainant's spouse.
Yes, she did say that.
Yes, I have a motion when you would hear it, Mr. Chairman.
Okay, any other questions or discussion? Have any motions, Mr.
I
Blendon?
wanted to add into Mr. Blendon's comments, this is Judge Souter. I think when we have a process server actually file a false affidavit with the court, that's a very serious matter. I guess it's at least tampering with government records, either a Class A misdemeanor or low-grade felony, depending on whether the tampering is material, I believe, and it could be even seen by some people as a perjury. I don't know. It's just really serious, and I've been kind of thinking about Mr. Blendon's comments over the last couple of meetings when we get into these cases where they perjure themselves or lie or misrepresent, file false affidavits to just, and I know you got a lot of cases and we got to move them. I understand the practical side of that, having been a DA, but I'm like Mr. Blandine. I would like to see us get a little bit more serious on putting a message out that when you do this, you're going to lose your ability to serve for, a while and pay a stiff fine if you want to come back, or both, anyway, those are just my comments.
And Your Honor, you can deviate from the penalty that is part of this default order, which assessed every possible violation that can be alleged against this respondent and assessed a maximum financial penalty of $500.
It does not include a suspension or anything, though, or even a suspended suspension?
Let me double check.
I don't believe it did.
We recommended, or the committee that heard this case recommended, that she complete a 7-hour pre-certification civil process education course and a penalty of $2,500, which is a maximum for all those violations. But we did not take action on her certification.
Okay, do we have any motions in regard to altering the sanction and or approving the issuance of the final order by default?
I would move to amend the sanction by adding that the process server certification is revoked. This is very serious, and this goes to due process. And if he swears he made personal service and handed it to a spouse, well, in many cases, the spouse hands it to the defendant, but what if they don't? And then 7 years from now or 10, he files an attack and alleges void judgment, and the matter probably would be overturned. I would move to also revoke certification.
And Mr. Blendon, what is the time period for revocation?
Well, I don't think there's a time period for revocation, but I would be open to amending the motion if it was requested that we say he can reapply in 2 years if he's paid the fine, for example. My understanding is if he's revoked, he's revoked. He's like anyone else that may later want to apply And I'm not certain on what our procedures are. If we don't put it in the motion, I assume at some point he could reapply.
I think
I
if
don't
we
know if
don't,
that's right.
I think if we don't put a time period in the sanction, he could apply the very next day after the final order is issued. If you put a time period in the sanction, I believe he may have to repeat some of the initial requirements for certification, but I'm not positive on what those would be. If he has to take a examination, not quite sure who might know.
Mr. Gibson, do you have any input?
We
Gotcha.
can't hear
Audio's
you.
not working.
My concern on some of these is going to the complaint review committee on these types of situations. We understand that their person falsified a return. Are these cases where they're not recommending a suspension or further? Are they cases where maybe they made the determination that these were more of sloppy rather than intentional misconduct or knowing misconduct?
I think in this case,
or sloppy returns.
I think in this case, they may have
Bad business
considered,
practice.
I think in this case, they may have considered that she admitted wrongdoing and she apologized in her answer. But I would have difficulty remembering exactly what the discussion was because it was some time ago. I don't know if anyone else recalls.
I believe that they did discuss whether or not if she had an intent to falsify the document. And I think after reading her answer and everything that was submitted, it didn't appear that she had done that. So they took in those mitigating circumstances into their final determination for that case.
Well, as long as we're considering their intent, and I'm not going to substitute my intent for the investigator and the subcommittee. If it looks like it was done on purpose, then I think it needs to be more serious. If the court reporter board felt like that it was not intentional, and I don't know about the paperwork being handed off to the spouse. That sounds a little bit fishy, but do we have any cases on this docket where they did it intentionally, but were not suspending or revoking, or is this a consistent theme on every one of them that, well, they didn't really intend to? So I'm just wondering if we are drawing a fine line and trying to decide whether they intended to or not, which I think we should. If they know better and they do it, and I mean, Mr. Blendon's correct. That's a huge deal. And so, but I don't want to substitute my judgment for the investigator and the subcommittee. So if they found that in good faith they thought they were serving, you could argue that either way. Then I respect that and would support that.
Judge, with respect to consistency, I think one of the settlements that was just approved pertained to a process server who felt he didn't do anything improper. That's why he didn't accept liability for that. So,
okay. And then we need to distinguish between doing it on purpose versus, the act versus the consequence. I guess we might need to, talk about that, because if you can get out of serious trouble by just saying, well, I didn't know, or I didn't, I thought I was doing the right thing, even though they weren't, then we need to have a mechanism where that kind of conduct is not acceptable when it looks like there's no way that they could believe that was, a service. So I'm kind of with Mr. Blandine on some of these, but I'm open to hearing the investigator and the subcommittee's report and their findings, and I highly respect that. Although it's not absolute, but I do respect it very much.
And Judge Souter, just to let you know that we do have another one on this agenda that is a little similar. And I believe that it's coming up a few down. It's going to be cause number 418. You had asked about that, so we do have one that is similar and also similar in sanction.
Okay, thank you.
Jeff, do we have anybody here from that committee?
Judge,
attempted-
Justice Raspberry was supposed to be here and he's not in the meeting. Is he waiting, Thais, or? No, Judge, I apologize. The justice.
He hasn't called in.
All right, well, do we have any motions to resolve that matter? Anyone like to weigh in?
Could I make a further comment on the return of service, Mr. Chairman?
Sure.
Now, to confirm, we are on 418 element. Is that correct?
That's correct.
Okay. The return of service, states that it is signed, I declare under penalty of perjury the foregoing is true and accurate. On December 15th at 6:15, I received the citation. On January 18th, I personally delivered said documents to Jennifer Birdsong at Denton, Texas, with the address. Additional comments, subject to accepted service with direct delivery. And I declare under penalty of perjury, this is true and accurate. And I don't know if my motion is still pending. And I would consider amending it if there was if someone would support revocation, allowing them to reapply for certification after 2 years and after paying the $2,500.
Would it also be possible, rather than trying to do this without knowing what went on in the complaint review committee hearing, would it be possible to just reject the default order or reject it and send it back to the complaint review committee for further assessment?
Mr. Chair, can you hear me?
Now I can.
My apologies. I've recently switched to a docking system instead of my traditional desktop. I'm having trouble connecting. I believe that is an option, or you could just, but I believe what you have before you now is Mr. Blinden's motion to amend the sanction.
Right.
And I don't know if Mr. Blinden
if that gets
would like-
voted down, I'm trying to think of other options, so.
All right, so Mr.
Okay.
Blinden's motion's on the table. Do we have a second for that amendment of the sanction? Anybody wish to second it?
I'll second it.
All right, so we have that motion to amend it, and as he outlined, it's seconded. Any other discussion in that regard? All in favor, please say aye by holding up a hand.
Aye.
I've got a 1, 2, 3, 4, 5 in favor. Any opposed? 1 opposed. It carries. Let me ask Jeff, this seems to be a continuing issue about us having concerns of, basically they're committing perjury, and we could refer it to the DA's office in the respective jurisdiction to see if they wanted to proceed on a criminal offense. Can we express our concerns to the committee about when they are absolutely unequivocally committing perjury and filing a false affidavit? We want to see perhaps a little stricter, tougher sanctions involved, or can
Yes, of course, Judge, we will do that. And we'll also, in our recommendations to the committee, make them stronger as well.
All right. I appreciate it. And if we can, It'd be good if we could have somebody here just to get their side of it, but unfortunately, we don't have that today. So moving on to the next one, Ms. Mohan.
Thank you, Your Honor. In the matter of David Hulkowitz, Ms. Saucedo, this case concerned the allegations in the notice of violation letter.
Yes,
Did you notify the respondent of the committee's determination by first-class mail, certified mail, and email?
yes,
Was that the October 3rd, 2023 letter?
yes,
Isn't it true that the letter sent by email and first-class mail were not returned?
yes,
And the certified mail was claimed?
yes,
And all the letters were sent to his last known mailing address on file with the commission?
yes,
And you did not receive any response from the respondent?
correct.
Did you notify him of this meeting and he's not present today?
Yes,
Your Honor, I believe that we've established that he had notice of his rights and we did not receive a written request asking for a hearing or settlement. We move for a default order. We ask that the commission move to adopt the findings of fact and conclusions of law outlined in detail in Exhibit 1 and adopt the sanctions stated in Exhibit 1.
Okay, so do we have a motion in cause number 0426 to issue the final order by default, accept the findings of fact, conclusions of law?
So moved.
Second,
Second.
any discussion? All in favor, please say aye.
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 Anyone opposed? Motion does carry. Cause number 0429.
Thank you, Your Honor. Ms. Saucedo, did this case concern the allegations in the notice of violation letter?
yes,
Did you notify the respondent of the committee's determination by first class, certified mail, and email?
yes,
Is that October 3rd, 2023 letter, Exhibit 1?
yes,
Isn't it true that the letter sent by email and first class mail were not returned?
yes,
Isn't it true that the letter sent by certified mail was sent to a vacant address that was the last known mailing address
yes,
for the respondent? Did you receive any response?
no,
Did you notify her of the meeting today and she's not present?
correct.
Your Honor, I believe that we've established notice and that the respondent did not respond to the written notice. We asked for a default order. We asked that the commission move to adopt the findings of fact and conclusions of law outlined in detail in Exhibit 1 and adopt the sanction stated therein.
Thank you. Do we have a motion adopting the recommendation and the findings of fact?
So moved.
Second,
Second.
any discussion? All in favor, please say aye.
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 Anyone opposed? Motion carries. Final order will be issued. 0460.
Ms. Saucedo, did this case concern the allegations in the notice of violation letter?
Yes,
Did you notify the respondent of the committee's determination by first class mail, certified mail, and email?
yes,
Is that the October 3rd, 2023 letter?
yes,
And this was sent by email first, and the letter sent by email and first class mail were not returned?
correct,
The certified mail letter was unclaimed?
correct,
And all of the letters you sent were sent to his last known mailing address on file with the commission?
yes,
And you did not receive a response, correct?
that's correct,
Did you notify him of this meeting and he's not present today?
correct,
Your Honor, I believe we've established notice. The respondent did not respond to the written request for an answer. We move for a default order. We ask that the commission move to adopt the findings of fact and conclusions of law outlined in detail in Exhibit 1 and adopt the sanctions stated therein.
We have a motion approving that final order by default, adopting the findings of fact, conclusions of law.
May I comment, Mr. Chairman?
Yes, sir.
This is similar to false return, but actually in this case, it was a false 106B statement. A false return is when you make a false statement on a return of service, reporting service on a defendant. In this case, as I understand it, they were unable to serve the defendant personally, and they filed a motion for substituted service under 106B, which requires a sworn statement or statement under penalty of perjury. And I think that in the documentation here, it alleges false return when it's actually, as is stated in finding of fact 2, you swore in a Rule 106 affidavit that you attempted to serve the complainant on these dates, and that is accurately stated there. I just wanted to note that, and with that, I would move to approve the recommended penalty.
All right, so we have a motion asking that final order be issued by default and adopt the findings of fact, conclusions of law. Do we have a second?
Second.
Second.
Any discussion? All in favor, please say aye.
Aye.
Anyone opposed? Motion does carry. I believe we're up to 0499. Is that right, Ms. Mullins?
That's correct, Your Honor. Ms. Saucedo, did this case concern the allegations in the notice of violation letter?
Yes,
Did you notify the respondent of the committee's determination by first-class mail, certified mail, and email?
yes,
Is that the October 3rd, 2023 letter, Exhibit 1?
yes,
And the letter sent by email and first-class mail were not returned?
it's correct.
And the letter sent by certified mail was claimed?
Yes,
The letters were sent to her last known mailing address on file with the commission?
yes,
And did you receive any response?
no,
Did you notify her of the meeting and she is not present today?
that's correct.
Your Honor, I believe we've established that the respondent had notice and that she did not respond to the request for a written answer. We move for a default order. We ask that the commission move to adopt the findings of fact and conclusions of law outlined in detail in Exhibit 1 and adopt the sanction stated therein.
Do we have a
May I
motion
comment?
after that final order?
May I comment, Mr. Chairman?
Yes.
And I just wanted to point out, this is a false service case. And in this case, the recommendation does include revocation. Revocation of certification and a $3,500 penalty. And I would recommend we approve the suggested sanction.
Mr. Blendon, I think there's 2 cases for Miss Boger. One is 0499, and in that one, we're recommending CE and a penalty, but in the other one is the one that we're recommending revocation.
Oh, yes, 0569. You're correct. Pardon my error, and I would approve on this case. I would recommend the suggested sanction. I move to approve the sanction suggested.
All right, so in 0499, we've got a motion to issue the final order by default, approve the findings of fact, conclusions of law by Mr. Blendon. Any second?
Second.
Any discussion? All in favor, please say aye.
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 Anyone opposed? Our second one on Boger 0569, Ms. Mullin.
Thank you, Your Honor. Ms. Saucedo, did this case concern the allegations in the notice of violation
Yes,
letter?
yes,
Did you notify the respondent of the committee's determination by first-class mail, certified mail, and email?
yes,
Was that the October 3rd, 2023 letter, Exhibit 1?
yes,
Isn't it true that the letter sent by email and first-class mail were not returned?
it's correct.
And the letter sent by certified mail was claimed?
Yes,
The letters were all sent to her last known mailing address on file with the commission?
yes,
And you did not receive a response for her, correct?
that's correct.
Did you notify her of this meeting and she's not present today?
That's correct.
Your Honor, I believe that we've established that the respondent had notice and that she failed to respond. We move for a default order. We ask that the commission move to adopt the findings of fact and conclusions of law outlined in detail in Exhibit 1 and adopt the sanctions stated therein.
All right, do we have such a motion?
So moved.
So moved.
Second,
Second.
any discussion? All in favor, please say aye.
Aye.
Uh,
Aye.
Anyone opposed? That motion does carry. Cause number 0569, which is our last one. Moving on to Roman numeral 7, the Advisory Board Complaint Review Committee to dismiss complaints.
Thank you, Your Honor. For agenda item A of this section, in the matter of Sachiko Nagao, this case concerned a delayed response by the pool reporter to inquiries by the complainant. The committee reviewed the case and determined that the conduct did not rise to the level of a violation, and the recommendation here is to dismiss.
Okay, do we, you know what, Judge Souter, would you do me a favor? Could you take over on this one? She works in the Bear County Courthouse. I'd like to not
Okay.
participate.
All right.
So the requested motion is to dismiss this complaint.
All right, there's a motion to dismiss the complaint in cause number 0415. Is there a second?
Second.
All right, we have a motion and a second. Is there any discussion on the motion?
I don't know who made the
There was a
motion.
motion on this one, Judge Souter, but I make a motion to dismiss, follow the recommendation of the advisory.
Did you say you want to make a motion to dismiss?
Yes, sir.
Okay, we already have that pending in front of us, I believe. So
don't
there's a
think
motion
you-
and a second to dismiss the complaint against Miss Nagayo in cause number 0415. And I'm just asking for any comments or discussion before we take a vote.
Judge Souter, I may have created some confusion. I
Okay.
stated the recommended motion. I don't know if actually anyone said so moved.
No, nobody made the actual motion. It was just seconded.
So
Okay.
that's why I said I'd make a motion to move, so.
Okay, y'all are way ahead of me. There is a let's do it again. There's a motion to follow the recommendation and dismiss the complaint in cause number 0415. Is there a second?
Second.
All right, there's been a motion and a second to dismiss the complaint. Is there any discussion before we take a vote?
One question, I did notice that the committee differed from staff recommendation. The staff recommendation was to fine and issue a reprimand. Can staff elaborate on that?
Yes, ma'am. When we looked at this complaint, we noticed that the respondent replied 224 days after the initial communication. There was a second communication, and for that one, the respondent replied 203 days. She did not provide an explanation for the delay because the respondent did not provide responses to both of those email inquiries. Staff recommended a reprimand and a penalty of $250 total due within 12 months after the date of the final order. And that was for violation of Code of Ethics 10M.
That's it. That's all I had.
All right, any further discussion or questions? We got a motion and a second to, I guess, follow the committee's recommendation that it be dismissed, even though the staff had a different recommendation. Does anybody have any more discussion? All right, all those in favor of the motion say aye.
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 All those opposed, same sign. All right, motion carries. That complaint is dismissed.
I would also like to have the record indicate that I abstain because I also know this court reporter.
Okay, the record will so reflect. Thank you very much, Judge.
So
Thank you,
moving-
Judge Souter. Let's move on if we could to item B 0384, Ms. Mohan.
Thank you, Your Honor. This one was dismissed for lack of evidence and issues of credibility. The recommendation is to dismiss.
Do we have any motion in that regard to adopt the recommendation?
So moved.
Second,
Second,
Second.
any discussion? If not, all in favor, please say aye.
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 Anyone opposed? Motion carries, dismissed. Roman numeral 8, administrative dismissal of complaints, process server certification 0398.
Your Honor, with your permission, may I please take A through F as a block because the basis for the dismissal is identical for all of those cases.
Be fine, please do.
Okay, so for A through F, Your Honor, we ask that the commission ratify the administrative dismissal of A through F on the basis that they do not clearly allege misconduct due to credibility issues.
Any motion to adopt the recommendations?
So moved.
Second. I think I heard a second.
Second.
Any discussion? Okay, in regard to all of those matters, A through F, if we're adopting those recommendations, if you agree with the motion and the second, please say aye.
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 Do we have anyone opposed? Motions will carry A through F. Court reporter certification, G through F.
Yes, Your Honor, I respectfully request to take G and H together because they have identical reasons for dismissal. G and H deal with misconduct that was not intentional. So we felt it did not meet the definition of misconduct under our laws. We asked that the commission dismiss or ratify the administrative dismissal of G and H on the basis that they do not clearly allege misconduct.
We have a motion in regard to G and H in that regard.
So moved.
Second,
Second,
any discussion? All in favor, please say aye.
Aye.
Anyone
Aye.
opposed? Motion carries and each of those two dismissed, I and J.
Yes, Your Honor, for I and J, there were there's no basis for finding a violation. And they both clearly do not allege misconduct.
All right, do we have a motion to accept the administrative dismissal?
So moved.
Second. Second.
All right, any discussion? If not, all in favor, please say aye.
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 Anyone opposed? Those motions carry. They're both agreed. Administrative dismissal, guardianship certification 0600.
Thank you, Your Honor. The complaint was filed against a family member who was serving as guardian and does not have to be registered. Guardians who do not have to be registered are not within the jurisdiction of the commission. That's the basis for the administrative dismissal, and we ask that the commission ratify it.
Motion to ratify the administrative dismissal.
So moved.
Second.
Motion and second, no discussion. All in favor, please say aye.
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 Anyone opposed? That motion carries. Request for reconsideration, Roman numeral 9, process server certification.
Thank you, Your Honor. May I please take A and B together, Your Honor?
Please do.
For both of these cases, the request for reconsideration, complainants did not provide additional evidence. So the basis for the, we ask that the commission deny their appeal because there's no new information to consider.
A motion to deny reconsideration. Anyone wish to make?
So moved.
Moved.
Second.
Any discussion? All in favor, please say aye.
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 Anyone opposed? Motion carries. Was that on both of those? I'm sorry, Ms. Moen, 0573 and 0431?
Yes, sir.
Was that the motion that was made and seconded, correct?
Yes.
Then that carries and they're both dismissed. Item Roman numeral 10, request for reconsideration of denial of process server application. At this time, we are going to go into closed session pursuant to the commission's public meetings policy, section 8F, to deliberate on item 10 on the agenda, the application for certification. Members of the public will not have access to the closed session. I'll ask you to please stop streaming on YouTube. The current time is 10:57 a.m.